We have many teachers who are appointed as probationary teachers but are on a tenured track, which means if you haven't taught before, haven't had tenure before, that after 3 years, after successful completion of 3 years, your position ripens and you will be appointed on tenure. When there is a concern about tenure, and this typically arises in the 3rd and final year, we try to work with the employee and perhaps with his or her union, not always, but perhaps, to ascertain what the issues really are and see if we can resolve them short of a denial of tenure. When tenure is denied, and this typically happens within a few months of the end of the 3rd year of a probationary appointment, where the teacher is notified verbally and in writing that the superintendent will not recommend that individual for tenure, there are a few options. One option is a 4th year. There are some situations in which a school district will agree not to terminate that teacher at the end of a probationary term, but to grant a 4th year to see if whatever the issues were that precluded tenure after 3 years can be resolved in the 4th year. We have had teachers who have received that option in the 4th year, and some of them have actually been appointed on tenure, but it doesn't always happen that way. Another option is that you simply teach out your year and you will be terminated at the end of that school year. A third option, and it's something that we pursue, is the possibility of resignation prior to being terminated after the employee has learned that tenure will not be granted. The issue here becomes what will be on the employee's record going forward, and whether it's preferable for the employee to have resigned rather than to have to report to the next prospective employer that you were denied tenure and terminated. These decisions are made on a fact-specific basis, and every now and then we have had lawsuits based upon denial of tenure where we believe there's been some other violation of law. For example, a teacher who was being denied tenure based upon her report years ago in another school district of child abuse by a teacher. We litigated that case through federal court up to the United States Court of Appeals for the Second Circuit. We commenced the trial and resolved the case in the teacher's favor. So there are all sorts of options that can be explored. I would add that if a superintendent does not recommend a teacher for tenure, the school board may not grant tenure in those circumstances.